So Goesaert v. Cleary is really the last in the line of the old guard decisions by the United States Supreme Court regarding gender. Um, there is an interesting issue that adds a wrinkle on it in this case, and I'll talk about it to some extent, but I don't want to focus on it too greatly. So, in essence, the state of Michigan had a law which denied women the right to obtain a bartender's license unless she was the wife of the daughter of the man who owned the bar. Um, and so the issue before the case is a violation of the Equal Protection Clause. Well, the Supreme Court holds that this is not at all a violation of the Equal Protection Clause. It's that this law is not unconstitutional. Justice Frankfurter writes the opinion. And Justice Frankfurter writes that the fact that women may now have achieved the virtues that men have long claimed as their prerogatives and now indulge in vices that have long been practiced does not preclude the states from drawing a sharp line between the sexes, certainly with regards to matters of the regulation of liquor traffic. So it sounds very much like the Bradwell sort of decisions. And that shouldn't be too shocking. There is, however, an intervening factor here, and the intervening factor here is the 21st Amendment. The 21st Amendment, which basically ends prohibition in the United States, ends prohibition in such a way that it empowers the states to have a large degree of regulatory authority over any form of intoxicating beverage. And also the service and delivery thereof. And so states still are, and certainly were in 1948, very much empowered to make regulations involving any sort of intoxicating beverage. And part of this case deals with that. However, the other part of this case, the Equal Protection Clause violation, was handled very distinctly by the court and said this simply isn't a violation of the Equal Protection Clause. There were a number of dissents, three individuals in dissent, Justice Rutledge, Justice Douglas, and Justice Murphy. And all of them argued that what the Equal Protection Clause exists to do was to make sure that invidious discrimination, invidious distinctions in the law don't exist. And they argued that this is the perfect example of an invidious distinction that is based upon stereotypes and not based upon any sort of real hard evidence or fact. And so the justices in dissent say that, well, if the Equal Protection Clause exists to do anything, it exists to make sure that individuals aren't classified in an invidious way. And their argument is that this statute very clearly does that. It treats women differently from men, and it does so on the backbone of gender-based stereotypes, and therefore it should be a violation of the Equal Protection Clause. This, however, doesn't ultimately hold the day, and Justice Frankfurter's opinion becomes law, and becomes law for about 25 years. This is the standard in the United States. We have to understand Justice Frankfurter had a long history on the court. Justice Frankfurter was on the court well into the early 60s. And during that time period, he interviewed a young woman to be his law clerk. The young woman was a recent graduate from Harvard University. She had clerked for a number of circuit court judges. She graduated exceedingly high in her class. She came with a significant amount of credentials. And he ultimately doesn't hire her. And the reason why Justice Frankfurter doesn't hire this well-qualified young woman is because she had a child at home. And he felt that her family life would ultimately get in the way of her doing her job. The woman that Justice Frankfurter ended up not hiring was Ruth Bader Ginsburg, who ultimately goes on to tackle the exact sort of classifications that exist in Goesaert v. Cleary before the Supreme Court and pretty much establish a new era of jurisprudence for the court in terms of gender-based distinctions. And of course, after that, she gets elevated to the United States Supreme Court. Understand that Frankfurt's not hiring her because of her having a child home would simply be illegal today. But at the time, in the early 60s, it simply was not. But it shows you that those Bradwell type stereotypes were absolutely pervasive among the top echelon of the legal profession, including individuals who were sitting on the Supreme Court in the early 1960s. Times and attitudes generally begin to change as we move into the future, but there's one thing you need to understand about the legal profession, is that women en masse were not attending law schools in very large numbers, largely until the 1970s. Now, if you think about how long it gets an individual from law school to actual practice and representation on, for example, the federal bar in which these cases are argued, we're talking about another 10 to 20 years. So the individuals that were graduating in the 1970s didn't go on to really change the law until the 1980s at a minimum, or the 1990s. And the reason why Ruth Bader Ginsburg was so groundbreaking is that when she graduated from Harvard, she was in the first class that allowed women to attend Harvard University. Before that, for the entirety of its history, Harvard University Law was an entirely male-based institution. So the stereotypes that were pernicious among society were very well represented among the upper echelons of the legal profession, and really put into play the method by which Ruth Bader Ginsburg really makes a name for herself, which we will see in the next three cases, and ultimately leads to her elevation to the United States Supreme Court.